Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Betty Baker Marshall. Betty is an attorney, has her own law practice in Campbell, California, and she's been there since 1994. She is a certified specialist in estate planning, trust, and probate law by the California Board of Legal Specialization of the State Bar of California. Betty received her Juris Doctorate degree, which means her law degree, from Santa Clara University School of Law in 1991, and her bachelor's degree in public administration from the University of San Francisco in 1985. She is the co-author of the Continuing Education of the Bar Practice Manual on Conservatorships and Elder Law Practice, and speaks extensively on elder law issues and other topics related to estate planning and caring for incapacitated persons. And just by coincidence, we're going to be talking about caring for incapacitated persons today. So before we get started, I just want to caution our viewers that we are talking about areas of law. Betty is a California attorney. I'm a California CPA. And however, each person's situation is a little different, and we want you to get legal advice.
Correct.
So this is what we hope will be something to initiate a conversation for you and your own attorney. So just to sort of pre-frame what we're going to be talking about, Betty, in a sense, you and I are here. Many baby boomers are finding themselves caring for senior parents and friends. The great generation, which is our parents, is in its failing years. It needs to provide we need to provide for their long-term care. And so we need to talk about, or we want to talk about, you and I, a little bit of how do you help people in that circumstance. So I've been a trustee in the past. You know, you helped me out.
Yes.
So my brother-in-law's mother, who was in her 90s, I believe, when she passed away. My father passed away recently in his 90s. My mother's going to be 90 next year. My wife functioned as trustee for my father-in-law, who suffered from Alzheimer's, darn. So, but it's here, and many
That's
of us
right.
are dealing with it these days. It's
Right.
even in the news. So anyway, so let's talk about it a little bit. So I guess the first question is what is a durable power of attorney for healthcare?
Well, a durable power of attorney for healthcare is a document that is created, we call it executed, by a person who's called the principal to appoint another person as agent to make healthcare decisions for them. So it's a legal document. You can buy pre-printed forms, but it's best to see an attorney, I think, to ask questions about all of the features of it. One of the features is that all powers of attorney are revocable. So if you created a power of attorney, you could decide that you didn't want it anymore and revoke it. It can only be created by the principal. In other words, someone else can't create one for you. You have to do your own. And a power of attorney is a durable power of attorney, stays effective after your incapacity, even though you're incapacitated. However, though, you could say, I don't want that person as my agent anymore. A healthcare provider would not make a decision, which is a legal decision, on the spot if an elderly person's agent was helping them and they said, I don't want you for my agent anymore, and I revoke that document. The doctor would assume that they had the ability to make the revocation and wouldn't render the services at the direction of the agent. They would listen to the other person. Now, if the doctor thought that you didn't have capacity, they might take other steps, but
Right.
that would...
So capacity is a big, especially again when we're dealing with people with dementia and that sort of thing, and how do they feel today?
Yeah.
You may not even remember who you are.
Right, and capacity is an elastic thing. It's not just one thing.
Yeah.
I mean, people say, oh, she's demented, or she's not able to make any decisions, but really the law says that your capacity to make a decision is related to the decision at hand and the subject matter of that decision. So you might be able to make medical decisions, but maybe not manage a trust, for example. So,
Okay. What is an advanced healthcare directive?
Advanced Healthcare Directive is another document that a principal would execute, and in California there is a statutory document that's a combination of a durable power of attorney for healthcare and advanced healthcare directive. And the advanced healthcare directive tells the agent what they want generally at the end of life when there's maybe a terminal illness or a catastrophic injury. Well, you could have catastrophic energy, I suppose. And or, you know, maybe they're comatose or something like that. So obviously they can't make their own decisions. So it's an instruction to that agent. For example, they may say, I don't want to be resuscitated by pounding on my chest to restart my heart. If certain situations exist that the intervention would harm me, and what would happen is if I were revived, I wouldn't have a better life, I might be in pain. That would be one example. Or they might say, I don't want any tube feedings, or I don't want to be on a respirator. I like to be out of pain, so give me as much morphine as the doctor will, even if the doctor says that would hasten my death. So I'm not saying that that's what you would do. I'm saying those are the choices that you have on healthcare directives, so you want to be very specific.
Right. So some of these, like the Advanced Healthcare Directive, I guess the hospitals have some forms.
They do. In fact, the hospitals, when you check into a hospital, they're required to present a form to you. You don't have to fill it out. They have to give that option to you. So sometimes I see people for whom I've already prepared a healthcare directive and power of attorney for healthcare, and they'll come in with a form that they've also signed at the hospital. That may overcome some of the directions they have in the other documents, so it's best to combine them and figure out what you really want, because they may be contradictory.
Yeah. So part of what this relates to, these two documents that we just talked about, is when people do estate planning, they usually think, oh, I have to get a will and a trust done. But really, there may be other documents. Now, maybe if you're really young, these things may not be so much of an issue, although if you have an auto accident, who knows?
Well, I have had young, catastrophically injured clients, yes.
So maybe, though, I guess what I'm getting at is, if you've got somebody that's got we call them trust mills or whatever, that they're just sort of churning out documents, if you will, they may not be pointing out some of these things that you need to think about in addition, and especially, like I said, for when we're dealing with senior parents.
Right. Well, you know, one of the problems with getting what I call a boilerplate trust is if everything goes well, it might serve the purpose. But most people think of having a trust or any of their wills or estate planning documents as the document that they might use while they are feeling well, and then what will go into effect when they die. But in fact, many people, as you point out, are staying alive for a very long time and becoming incapacitated. And so there needs to be some careful construction of your plan for what happens when you're still alive and you are not able to take care of yourself or of the issues that are related to your property and your finances. And it's surprising how many people make no provisions for that at all.
Yeah, so you really need to think about that, and even in your trust agreement itself. So maybe we'll get into that. So what other preparations can you make for your care when your health declines?
Well, I suggest to my clients that one of the most important things that they do in this estate planning process is to have in-depth conversations with their family members to talk about what their wishes are. I mean, the Advanced Healthcare Directive and the power of attorney for health care can only go so far on paper. We don't know what specific circumstances will arise in the event of our illness. There are nuances and unusual situations. And so there's a need for the agent to have an an understanding of your values. I mean, let's say it's your son, for example. They may have a general knowledge about what mom's values are, but about these things, the answers are surprising. And it's a hard conversation, I think, to have, but it's an important one. There's another layer of grief before death and even after death, when the family members have had to make decisions without really understanding what mom or dad wanted.
And they wonder whether they did the right thing or what mom or dad would want.
They agonize. It's a very painful thing. And so it can diminish that mystery of what mom would have wanted about this. I mean, there's some surprising answers that your parents might give you.
Right. So you do want to find those out too. I know, like, as you know, when I was functioning as a trustee, especially that, you know, the situation, it wasn't my mother.
Yes, I remember.
So, you know, so I was regularly polling or talking with my brother-in-law and his brother about, okay, well, I mean, here's a decision that needs to be made. You know, how do you feel about this? You know, are you in agreement about, you know, taking this particular action and so forth? I was pretty lucky that for the most part they said, you know, I really trust you and think that you're going to make a good decision. It made things a lot easier for me in some ways, as far as, but then I still did have to make the difficult decisions. So anyway, but I think that that's important, though, that you have that communication that's going, and when the person's incapacitated, that there are other people that are involved, that they're going to want to have some input and not feel excluded, I think.
Well, you make a really good point, because you might have a discussion with your children, assuming they would be the people making the decision, and in fact they're not. Or maybe you don't want them to because they're not getting along. It would be important still to relay that information to them so that, as in your case, they can carry the message to whoever will be making the decision.
Right. Okay. Can you explain some advantages and disadvantages relating to health care for a durable power of attorney? So that's one thing. Or maybe it's together with other things. So then we've got a conservatorship, and then we've got a living trust. So how do these things sort of interrelate, and what are advantages and disadvantages of some of these?